What is a last will and testament? Sometimes we just call it a will, sometimes we call it a last will, sometimes we call it a last will and testament. So what is the document? Do you need one? And is it the best document for you to have as the cornerstone of your estate plan? So really, when you boil it down, the last will and testament does two important things. It lets you pick who is in charge of your estate after you die. In some states, it's called an executor or executrix. Here in Florida, by statute, we call it a PR or personal representative. Not a Puerto Rican. Racist. Anyway, the idea is that the personal representative will submit your will. First, they'll hire an attorney typically. They'll submit the will to the probate judge. Judge will look it over, say it's good, admit the will to probate as long as there's no problems with it. And then we do inventories and we do publications and we wait for creditor claim periods. And then we pay any legitimate claims and then finally distribute the assets. And that brings me to the number two thing the will does. So number one, puts the person in charge. And number two says where your stuff goes. That could be as easy as directly to your children, to your spouse, to your siblings, to charities, whatever you say. And that gives you control over the default rules, which here in Florida, if you die without an estate plan, there is a default set of rules. That may or may not be what you want for your assets when you die. So who's in charge? Where does my stuff go? That's the upside, is you get to take control and you're not stuck with the default Florida rules. The downside to stopping at a last will and testament to be the cornerstone of your estate plan is the probate process. Many people have a misconception that if I have a will and when I die, somebody brings my will down to the bank and then the bank just hands out the money based on what it says in the will. That is not how it happens, at least not here in Florida. So it would require a court order before the bank gives money to anybody. That court order is it's the byproduct of the probate process. And so there are attorney's fees, court costs, filing fees, publication fees, bond, paralegal fees, personal representative fees. All of those fees and costs, dollar for dollar, take money out of the hands of your family members, friends, or charities, whoever your beneficiaries are. So it is better than having nothing, but it is certainly not better than having a trust, which does the same thing as the will. Who's in charge? Where does my stuff go? But it avoids the entire probate process when done correctly. So if you don't care about your fees and costs after you die, the last will and testament may be just right for you. If you want more of your hard-earned and hard-saved money to go to the people and places that are important to you, then you should have a trust. Have a great day.